witness, Tony Zammit, testified that he was told that the electors would sign an affidavit stating that if evidence was found that would overturn the results of the election, that the electors would be willing to serve as electors. Zammit was clear that the intent of the document was to be contingent and that he saw Flynn pick up the document and later overheard him make a statement to the effect of, can you believe I have to send this to the Secretary of State or National Archives? But again, we have Renner who said that there was no testimony, that he had no clue that was going to happen. Zammit also testified that he believes that the electors just listened to what the lawyers who were present made them believe, and that Michigan would be disenfranchised and lose their vote if the election was later overturned, and that this was based on the Hawaii case, which again, they were made aware of by these attorneys that were not named in this case. The people's witness, Zammit, also testified that he believed the electors were misled and taken advantage of by Flynn, who was an attorney. This aligns also with some of Renner's testimony. He stated that he believed that defendant Maddock, this is Zammit, Michon Maddock, might be culpable. And the court did draw from the proofs that defendant Michon Maddock did seem to be one of the few defendants that had direct communication with the Trump lawyers campaign. People's witnesses, or witness Laura Cox, also testified that she received a call from the Trump campaign and lawyers, and that the plan, as she knew it, and she's one of the creators of this meeting, right, the organizers, that the electors were to convene and sign the document stating that if the election was overturned, the electors would serve their duties. She thought this was a good option versus other documents that had been shared with her. Her testimony was that she provided the document to the Michigan Republican Party staff to present at the meeting. She had a key role there. It was her belief, as the person case pending, that there were cases pending that could impact the election. That was her belief, and that those pending cases could affect the results, and that she wanted, or that they wanted, their document in place in case the election was ever overturned. She helped organize this meeting. She also testified that she believed that the slate sign would only have power if the election was overturned. This was also based or consistent with Renner's testimony. And so it's easy for the court to assume that this was the idea that was conveyed at the meeting. People's witness Terry Land, who was an original nominee elector, was the only witness, I believe, that the court could reasonably believe or be confident had some sophisticated knowledge about how the electoral process ran, and that's just based on her prior role as a Secretary of State. She testified that she was contacted by defendant Michon Maddock to attend the December 14th meeting at the request of Trump lawyers. Land said she told Maddock to have the lawyers call her. The lawyers never called her. She never showed. The court believes that was intentional. Just like when the other witness testified that they were told not to tell the electors what they were coming here for, that was intentional, and that the lawyers did not want to disseminate certain information to the electors. I believe that based on the testimony, the Trump campaign lawyers intentionally kept that information from certain electors, and that they were the ones who controlled the narrative of this meeting. And that, again, is consistent with the people's chief witness, Mr. Renner. People's Exhibit 26 is a picture of the group at the headquarters after this meeting, after they signed this document, and they're posing. And when the court reviews this picture, it appears as if this group of nominated electors believes that they're documenting something important, that this is some historical or monumental moment for them. Typically, people who are seeking to defraud or deceive do not gather and make a spectacle of that. That would be weird. Now, the people's chief investigator and witness took the stand, and he had a time on the stand. His time on the stand multiple times, because I think there was a time we had to call and recall him multiple times, called into question his credibility as well as his preparedness for this particular case. had to make, and the court had to go off the record multiple times to allow witness Shaw to review his notes or find answers on reports, about reports, in case that he again was the sole detective on. Portions of Agent Shaw's testimony caused some confusion, or at least appeared to cause him some confusion during the questioning. And he testified that the evidence suggested that Flynn was the one who mailed the documents to DC. Again, Ritter testified the electors, he being a substitute elector, had no knowledge of this. Agent Shaw testified that he interpreted evidence he received and reviewed to believe that defendant Sheridan relied on guidance from Trump's lawyers, Giuliani and Chesbrough. He testified in this courtroom under oath that the electors did what they were told to do by the lawyers. And the court agrees with the argument made by some of the defense counsel in their mind over that reliance on counsel's advice, although not an affirmative defense, does tend to refute the government's ability to prove intent. Agent Shaw conceded on cross-examination that there was no public record. That was his response. Agent Shaw received emails from Chesbrough after swearing to an affidavit of probable cause that would demonstrate that there was no agreement between these named defendants to commit a crime. Although he put in his affidavit that the electors were told this would be an alternate slate. Agent Shaw testified that he believed Mr. Ritter was doing his civic duty when he signed the very same document that the other co-defendants allegedly signed. So that would mean that they were doing their civic duty, if I were to believe Agent Shaw's testimony. Agent Shaw testified that he moved forward with authorizing the complaint because of a concerted effort to present a slate to cause a pause in the electoral process. But that's not an element of fraud, and not an element of the charges before the court. This is not an election interference case, and there's many things that could cause a pause in the electoral process, and it doesn't mean that it's criminal. This is a fraud case, and we have to prove intent, and I don't believe that there's evidence sufficient to prove intent. I believe there's insufficient evidence brought on this record to even establish that the defendants were trained or explained to them what their duties would be, and the difference between a duly elected elector versus an elected or nominated elector. Agent Shaw testified that there were no distinctions between the actions of Renner and the other co-actors. That was mainly in response to, I believe, Gilbert's cross-examination about his client, Thompson. But if there's no real distinction and Mr. Renner was doing his civic duty, then that means that they were all doing their civic duty. The prosecution would like the court to believe that these named defendants were savvy or sophisticated enough to understand fully the electoral process, which the court does disagree, because the document that was presented doesn't even align with the level of sophistication that they want me to believe. This alternate document doesn't state it's an official document of the state of Michigan, doesn't contain a certificate of vote. No one attempted to forge the governor's signature. No one attempted to create a fake seal. There were also some social media posts that the court can interpret as the intent from. I think it was Ms. Lundgren's social media post indicating that they were in Lansing fulfilling their constitutional right, which doesn't demonstrate an intent to defraud. It's an intent to exercise what you believe is your constitutional right. And she also stated in that post something about they were well documented, meaning that they're preserving their right and they got proof of that they preserved their right. The court could have possibly entertained the concern regarding LaShawn Maddox's culpability but for the People's Exhibit 18, which was a video, but appeared to be a press conference with LaShawn Maddox and Sheridan, which clearly states what their intent was. They clearly stated that and this was right after, I guess, after the December 14th meeting, where they said they were executing their constitutional right to allow the senators of the state of Michigan to receive an alternate slate, and then the senators could take further action. They didn't say, first of all, I don't know anybody doing a press conference after they're committing a fraud, but to the extent that that's what we're going to do. other individuals in the state of Michigan who sincerely believe, for some reason, that there were some serious irregularities with the election or with the voting, and that somehow their candidate didn't receive all the votes that was intended to from them. This is not for the court to decide whether that was true or false, but this was their belief, and their actions were prompted by this belief. It is understood presidential candidates to seek redress for a recount, and that didn't happen in this case. However, it is also understood that the Constitution of the United States provides, under the First Amendment, a guarantee that people can peacefully or peaceably assemble and petition the government for redress of grievances, and sending an alternate document or a document to the state capitol, which is what the testimony was their intention, and that's evidenced by the video. We're the other electors, and we got something that we got to get to them too. They knew that the Democratic electors were there. They were trying to sneak and get something that looks like it's the real one and replace the other one. That would be an attempt to defraud. They know that the Democratic electors are there casting their vote. They've been told something about this weird Hawaii case, and they think that they got to get their stuff in on the safe harbor deadline or by December 14th. And so the actors, based on the statement of Ms. Maddox and Ms. Sheridan, were corporately seeking to get the Senate to move and do some action, because apparently the courts weren't giving them what they wanted. And so in this courtroom, we don't really care your race, color, creed, national origins, religious belief, or your political beliefs, but we do care about the law, and that we believe that it should be applied to protect every individual equally. And I believe that they were executing their constitutional right to seek redress, and that's based on the statements of all of the people's witnesses. And so for those reasons, these cases will not be bound over to the circuit court. Each case will be dismissed. Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honor. Justice is served.
Yep.
It's a memorial. Bless your heart.
Are you still jogging, are you?
I am, sir.
I developed some knee injuries over the winter and there's all harvest last year and everything, so I'm just now getting back to walking.
Good for you.
But at 75, it takes a little longer than
Yeah, need some assistance? I can grab the bag.
Do you want me to zip it up so you can just wheel it?
What's that?
Well, do you want me just to make it so you can wheel it?
Yeah, that's fine.
I just don't want to break it all out.
Yeah.
You know what I mean?
No, I totally understand, because I want to see if we can get one of them to talk.
So,
Can we squeeze past you guys? I'm so sorry.
We knew when we went through the
Can we
preliminary
squeeze
hearing.
past you? I'm so sorry. Thank you very much.
Yeah, I'm grateful that it came through today.
Can I get your name?
My name is Hank Cho.
Oh, you're Hank Cho. Okay.
Yep, Kyle. Thank you.
She did a great job.
Help, this was perfect.
She did a great job.
You're going to the yeah.
Congratulations.
We still got court going on. We got to be quiet on the way out. Let's go. No, we shouldn't. No, come on.
Yes, he did. We love you.
It's worth every dime. You did. There's questions of
So I'd like to get a response from one of them. I don't know if we should follow them downstairs.
I heard they're going to do something out front, like a scrum.
John,
They're what?
I think they're going to do a scrum out.
Oh, are
I
they?
said things.
Okay.
Why do I feel so privileged that I get to stay in there today?
It's a relief for everyone.
Yes, yes. Thank you for what you did.
It's my pleasure.
You got the mic, right?
Yes.
Oh, yeah, okay.
Thank you. I know this could probably.
I did it, but I
No, I know you don't.
But we were in good hands.
I love you.
Okay.
It's interesting.
Yeah.
They kept it pretty.
Yeah.
I have an idea of the attorneys, so I'd like to maybe.
I'm still on, by the way.
Are you?
So don't feel free to talk amongst yourselves.
I got you.
But you can leave it on.
Are you sure?
Yeah, because if they want,
Okay.
you know what I mean?
Yeah, I don't think they were. She was saying, let me know when they come to a decision. So I think they were gonna cut it.
Oh, okay. I didn't know if they were still wanted to
Yeah.
feed it
Are we on?
to NBC.
No.
Yeah, lobby. And if you hold the button,
I had to get.
no, once they get in,
Oh, I didn't hit it. But it just
if you hold it in, it won't stop at any other floors. I'm telling you.
Come in here.
One more pick.
Who are you with? Here.
How long ago? Oh, thank you.
Thank you.
Swap out the mics.
Yeah. There you go.
Justice is served.
Can we get it on camera? I've just got a couple questions.
Sure.
Is okay?
Sure.
All right.
Have one of the attorneys with us as well.
Great, yeah. We can do it doubled up. I'm just gonna put my stuff down here. Work. They're gonna do.
You want to swap out the mic?
Yes, I think we should. I'm gonna pop this on. Yeah. I can grab it. That's okay. Yeah. You're like cooked up.
As I kept saying, 7 minutes of preliminary hearing, I knew what the outcome was going to be.
Pop that. Off.
Yes, you did.
Thank you. Okay. All right. Ready? Testing 1, 2, 3. 1, 2, 3. And I think the batteries are probably dead.
She's the only one I recognize.
I know I've been with you on this for
Exactly.
so I'm looking forward to hearing what you have to say.
Sorry, guys. Give us 1 second. Okay. You getting audio now? Testing 1, 2, 3. All right, perfect. Ready?
If you could do us a favor, if you can say and spell your first and last name for us.
My name is John Freeman, Johnfreeman. I'm a criminal defense attorney out of Oakland County, Michigan.
And who did you represent?
Marianne Sheridan.
Go ahead.
I mean,
My name is Hank Choate, Hankchoate. I'm a farmer from Jackson County and a proud American.
talk to us about what today means for you guys.
Justice was served.
Yeah.
I think it's a true testament to the way the system is supposed to work. We're very grateful for the judge taking the amount of time that she did to go through everything. There was an awful lot for her to consider, and she got it 100% right. We've been saying the things that she said from the bench since the very beginning of this case. The only way to really fairly look at this is it was a politically motivated witch hunt. That's the only way that I can look at this case. The evidence, or I should say really the lack of evidence, was just astonishing. And the fact that we came this far is scary.
Can you talk a little bit about what comes next?
That'll be up to the Attorney General's office. I think we're all going to have a great day on our side of things. But if you're asking about legal procedures, where does it go? The Attorney General's office certainly has the right to appeal to the circuit court if that's what they want to do. I'd be surprised if they went in that direction, but there's an awful lot of things that this Attorney General does that's surprising.
Any opening here for civil litigation against the AG's office for unlawful prosecution?
That's certainly something that we're going to evaluate, whether there is a viable case for malicious prosecution.
For our defendants here, can you talk to me a little bit about how you're feeling?
I'd like to say that I'm overwhelmingly happy. However, I'm really kind of angry that we got to this point. This should have never happened. This was clearly malicious prosecution.
Yes.
I just so appreciate that that Judge Simmons, who is a Governor Whitmer appointee, got it right, and she saw through it, and she held to what is just.
Amen. Amen.
And so
Mary.
I just so appreciate that she set aside any possible political pressure and looked at the facts and made the correct judgment.
That's why things work the way they're supposed to. That's why they work today the way that they are supposed to.
Because of the judge or because of the court system?
Because of the way that the judge went through methodically and analyzed the case, analyzed the evidence, the lack thereof, really, and reached the right conclusion after applying the law. She did a great job.
Yeah, I think her point on the intent was probably, she emphasized the lack of any evidence, a shred of evidence of intent by my client or any of the electors to defraud or do anything illegal. And as the judge kind of tongue-in-cheek said, you don't pose for a big picture when you're committing a crime.
Exactly.
I mean, I think that says it all right there. That we're very pleased. Judge Simmons, as John just said, methodically went through the evidence, and it's the correct decision legally, and I just can't be happier for my client.
Could you spell your name for us?
Yeah, it's Kallman, David Kallman.
And then who did you represent?
Hank.
Great.
And so, what I can say as a dairy farmer my entire life, never thought I would be charged as a criminal, sitting in the courtroom. But what I can say is that watching the judge, I have to say, as I was completely impressed watching her through those 7 days of preliminary hearing, how she was able to stay on track in regard to what was being asked of the attorneys towards the investigator and this and that and everything. And I've said all along is that Dana Nessel, her primary objective, whether she won or whether she lost on this case, came down to political persecution and also political intimidation. Each of us could have say, okay, we were willing to help with the turning state's evidence, but we stood solid, we demonstrated courage, we felt and knew in our hearts that we were right in what we were wanting to do, and no way were we going to bow down to political persecution or political intimidation.
Thank you.
Thank you.
Can we have everyone run through there and spell their first and last names real quick?
Just ask the same. Can we go down the line? Maybe?
Sure. Yeah.
I know we got things like
Marion Sheridan, Marian Sheridan.
John Freeman, John Freeman.
David Kallman, Kallman.
Hank Choate, Hankchoate. We got her done!
Mr. Choate, if I may ask. All right. So we have one of these guys out.
So what I can honestly say is that
We got one of these already, but I'm trying to think maybe if we should just get one. Who is that guy? Over here. I want to talk to him.
I was going to.
I mean, was he just the
He's a politician. He's running for something. Maybe he's like either a senator or a rep. I overheard him talking. He's like, I'm just here to support them.
Then honestly know him.
Yeah, because if you do, Mike will say, oh, you can't show
I
them.
thought he was like a.
Yeah.
I thought he was a different role. Okay.
I don't know that anybody was here.
Struggle getting this one.
Another one.
How'd the shots look from this one?
That's fine. Yeah, that was good. Just cut around the, adjustment.
Yeah. Hi, good morning. I'm Rachel Fulton. I'm with News 10 WILX. How are ya?
Fine.
Could I possibly talk to you? Are you on the call?
Give me a minute.
Sounds good. Thank you so much. You're going to talk to us. Okay. Just sorry.
Okay.
That was it.
I don't know. It's hard. It's in the sun.
Oh, that was crazy.
Yeah. Haven't I
I
heard?
think we were, and right there with the textbook example, like you get the court early, stand by the door.
Oh my God, so
get in.
smart.
You
Hello.
have some softball questions?
Yeah, I do.
Very
yeah.
soft.
That's okay. You don't have to be an expert or anything. You know, we're just trying to talk to you about what today means, just in your opinion, okay? Were you one of the ones? What brings you out today?
I'm one of the defendants.
Okay.
Was one of the defendants.
Very good. That's a great way to describe it. Yeah. Well, are we good for? Okay. So why don't you just go ahead and give me your name and can you spell that out for me?
Ken Thompson. At the time, I was the 3rd Congressional District, substitute for Kerry Van Leyen as the presidential elector for the 2020 campaign.
Oh God. And Ken, talk to me about what today means for you.
It means relaxation. It means the rule of law does stand, which is good to see and hear. I thought the judge handled herself adroitly. The case was long, as she said it was complex. I thought her decision was proper, and she was point on point to the Constitution. She addressed the facts as they applied to her.
Yeah. What's next for you? Where's your mindset? Did your mindset shift through any of this, or are you going to continue strong in what you believe?
I've stood up with the president since 2015.
Very good. Is there anything else that we should know, the community should know from your side today?
When you stand up on principle. With God's grace, liberty prevails.
Thank you so much. We appreciate your time today. That's good. All right.
Okay.
Got enough B-roll, some posters and stuff like that.
Well, I don't rate it. Hopefully Iceland.
What's that?
Hopefully Iceland when she was out.
Yeah, she got a
They
little
all just
bit.
sort of like.
We're good then.
Yeah, I think so. I can.
Can we get a shot of the Capitol just to have it if I just want to use it for a...
You got
I'm not familiar with that.
I love it. Let's definitely get together. Yeah, of course. Great. We're family. Thank you so much.
All right.
Oh, of course. Wonderful. Yeah, no, how I should balance this.
Like the nobody, I think, from the prosecutor was here. I guess. I mean, you could probably get a statement from him, you know, and do it as just a, you know, like a full screen or like, you know what I mean?
Yeah.
Unless you can get Dana Nessel.
Yeah, I know, for real. I could try and call them. Can you pop your mic in this little...
Oh, yeah.
Try and get a...
No, you're good, you're good.
Well, first I wasn't sure. She was just going on. I've been in situations where it's like,
Yeah.
George hired me.